Today's King's Speech will be especially significant for the family of Oliva Pratt Korbel. In August last year, 9-year-old Olivia was fatally shot by Thomas Cashman after he chased his intended target into her family home.
Cashman was sentenced to at least 42 years in prison, but refused to enter the dock to hear his punishment. Olivia's mum, Cheryl, and aunt Antonia have, since that moment, campaigned tirelessly to see the law changed, to force criminals to be present in court for their sentencing, and they have helped secure a historic change in the legislation.
They're hoping the new legislation will be known as Olivia's Law, and Cheryl and Antonia join us now. I guess it can't do anything to bring Olivia back, but it is an important step forward.
Yeah, it is a really important step forward. It does bring a little bit of comfort knowing that no other family will go through what we've been through.
Cheryl, tell us what it is like when the person responsible for the death of your daughter is not there at the moment when you could explain the impact of what he had done, and when he is not there to hear the sentence that is going to keep him in prison for 42 years. How important is his presence in court to you, the family?
It's really important. I really did want to address him, to tell him the pain that he's put us through, that we're still going through. And to have the audacity to be there every day for a whole month and not turn up on day of sentencing, it's disrespect to the family and to the judge to hear the sentencing being passed. I know I read my impact statement out, and hopefully at some point he may well have heard it. But the change in the law, it's no other family's going to go through it.
I know that there are some judges who are very worried about this because they worry about you, the family, and what happens if somebody who's showing no remorse is forced into the court to hear the sentencing and then is abusive, says terrible things. What do you say to people who say that's a reason not to do this?
Well, if they're going to be disruptive, make sure that there's measures in the cells for, you know, a screen or a speaker so they can still see and hear what is going on in the courtroom. So although they're not there in the dark, they're still being addressed if you've got circumstances where they are being disruptive.
So it's not necessarily them being there. The important thing is you want them to hear. Yeah,
because in that court process, it's one thing listening to solicitors and barristers saying, you know, how painful it is. It's completely different when it comes from a family member or the victims. It resonates a lot deeper, and if it makes them realise just a tad of what they've done, then yeah.
Antonia, there may be a penalty if they don't appear. Would that also make it better for the family to know there's been an extra punishment if they continue to refuse to be there?
We've discussed this in length, haven't we, as a family, and 24 months sounds a long time, but if you're looking at a really lengthy sentence, 25+ years, 2 years is neither here nor there. I think if you've got somebody looking at about, you know, anything from 10 to 20, then maybe 2 years does sound quite a bit. But once you've hit that 20-year mark, it's not. I mean, that's what they're suggesting and that's what they're going to be putting forward. And, you know, obviously we have no choice but to agree with that at the moment. Whether or not that's something that we look at campaigning against, if it's not a deterrent, I don't know.
And in the case of Lucy Letby, who also didn't come to court to hear the sentence, she, of course, was given a whole life order. So 2 years wouldn't make any difference as a penalty. No. We were speaking earlier to Andrew Pearce from the Daily Mail, who suggested that visiting rights should be denied to those who refuse to come to court in those circumstances.
Yeah.
Cheryl, would you endorse that?
Yeah, too right. I go and visit my daughter, but all I've got to look at is a stone. They can still see their families. It's not right.
Before we speak to the Government Minister, the Justice Secretary, Alex Chalk, you've had a year now, more than a year, without your daughter. And for our viewers, just tell us about Olivia.
She's missed every second of every day. It's trying to live a completely different life, because everything you don't realise until you lose that person on how impactful it is on everything that you do. I just feel she's with me all the time. Sorry.
I know.
She was a cheeky chappie, wasn't she? She was playful. She never stopped speaking. And I think a lot of the time it's the silence that we miss.
Yeah,
a lot.
Silence is the main thing.
And it was so it was so senseless, wasn't it? It was just such a kind of random act of terrible violence. It's impossible to kind of understand why it happened. There was just no reason.
Yeah, I think you tend to process it a little bit. If she was ill, she wasn't ill. She was just cruelly snatched.
You have shown so much courage, and I know you've used so much of that energy to put into something that is quite remarkable, to achieve such a historic change in the law in such a short period of time.
They've had a lot of energy, so I grabbed a lot of that to go out and do the campaign.
It's incredible what you've done, and as you say, it will bring comfort to other families, what you've done. And we can speak now to the Justice Secretary. Antonia, Cheryl, thank you. I know this is hard, and we all feel what you're feeling, and appreciate you sharing that with us and the viewers this morning. We just send you so much love. Thank you.
So the Justice Secretary, Alex Chalk, joins us now from Westminster. Mr Chalk, I hope you've been listening to Cheryl and Antonia there. Tell us about how this law will work in practice and the difference it's going to make for families like Cheryl in future.
Certainly, and can I first thank you for conducting that interview, which was incredibly powerful. And I just want to pay tribute to Cheryl, how she has found the strength to do this, to campaign at a time like this, but also what is so remarkable, because this does nothing to bring back her beloved daughter, but it makes life better for other people. And I just find that incredibly moving, and I'm grateful to her for it. So on the specifics, what this means is that where there was confusion in the past, as that person, having been convicted, that offender was down in the cells with their barrister, and the tannoy comes out, you know, this case has been listed for sentence, and that person says to their brief, do I need to go up? Now the answer is yes, you do. And that is critically important so that they can face, in the full glare of the court, face up to the consequences of what they've done. Because it's worth reflecting, during a trial, the judge quite rightly is at pains to ensure there's a fair trial. So everyone sort of keeps quite quiet, focuses very much on the evidence. But there comes a moment where there has to be a reckoning, where the full nature of the offending has to be let out, to be set out, the appalling impact it's had on people, what this person's previous convictions were, the danger that they've presented, whether they've got any mitigation, and also the point that you rightly pointed out, to ensure that they can hear ringing in their ears the victim personal statement from those friends and family who have been profoundly affected, because they will never get a good night's sleep in their life. So why shouldn't that offender have the enormity of their actions ringing in their ears when they go back into the cells later that day?
Alice Chalk, a couple of things to follow up on this. One is that 2 years is going to be the penalty, an extra 2 years added to the sentence if the offender refuses. In the case of the nurse, Lucy Letby, she's given a whole life order. 2 years will not make any difference. You can't add it to a whole life order. One of the suggestions, and Cheryl and Antonia support this, is that visiting rights could be denied to those offenders who refuse in those circumstances. Is that something you've considered?
Well, the first thing is I think that's an excellent suggestion, and I think it's absolutely something that we should consider. But there are two other points I want to make as well. First, to be absolutely clear that the court has this power and can order individuals can be expected to make a difference in the overwhelming majority of cases. I'm somebody who's been in court many times prosecuting, and the mere fact of the court making that order, whether it's to Lucy Letby or Thomas Cashman or everyone is, can be expected to have a significant impact. That's point one. Point two, on the issue of the default penalty in the event of that they refuse to come into court, this is something that we have to take in stages, exactly as Cheryl's indicated. Let's see how this works. Is it proving to be a deterrent? My hope and expectation is this is going to do the trick. But let me make no mistake. If this doesn't do what we expect it to do, then of course we will consider further measures to strengthen it up. And I will look forward to working with Cheryl and Antonia in future months.
And also the behaviour of the person who is convicted. There will be some people who still persist in disrespecting the court and whose behaviour may add to the distress of the family. What do you do if someone speaks out, abuses the court, puts their fingers in their ears, does something that actually compounds the suffering of the family who have lost their loved one? What do you do with that convicted criminal?
So, respectfully, that is an excellent point, and it's very important. I remember being at the Old Bailey at the time of that dreadful Lee Rigby case that you may recall at Bellagio, and there the defendants were using their platform in court to try to spew more hate and to try to further their warped message. Now, the critical answer to your question is trust the judge. So the judges are experienced judges who are well able to understand what is going to meet the justice of this case. Is this going to be a moment where I need to insist that that person comes into court? Or, in my judgment, is that person going to try and turn this into a circus, which in turn could rub salt into the wounds and heap torment upon torment for the victims? The judge should make that decision. So that is a really, really important point. And there will be cases...
Alex, just on that particular point, Alex. Just on that particular point about the judge, what powers does the judge have? Can the judge require force to be used to bring the prisoner into the dock? Can the judge have the prisoner gagged so that they can't make noises? How far does the judge's remit go?
So can I just finish the point? So that if the judge decides, for example, that he's going to keep the person in the cells, it's precisely the sort of issue that Cheryl was mentioning, that you can ensure that that person down in the cells gets those sentencing remarks and, if necessary, has them played into it. So we're looking at the technological solutions for them so that that can take place. So your specific question, it is about reasonable force. So reasonable force is a formulation that is well understood in the criminal justice system, so that it applies in respect of an arrest. Of course, the police can use reasonable force to effect an arrest. You can have reasonable force used by prison officers if they need to move a prisoner from cell A to cell B. So reasonable force is a formulation that is well understood, is ordinary English words, and this is something which applies in other courts. I was in France recently and I was speaking to the French judiciary, and they say, look, we have a long-established tradition of ensuring that if people don't want to come into court, we will use reasonable force so that they do so. But ultimately, the judge will know, is this going to, in the vernacular, kick off? In which case I might make a decision about using technology as I've indicated? Or is this just one of those cases where that defendant needs to understand the facts of life, namely, get yourself into court, face the music, face up to the consequences of your action, and let's ensure that justice is done.
All right, Alex Chalk, Justice Secretary, thank you for joining us this morning.
Thank you.
Thank you.
Cheryl and Antonia, I mean, you listen to the Justice Secretary there. This is all the result of, you know, your campaigning, of course. You feel vindicated to a certain extent.
Yeah, we just hope it works.
Hope it works, yeah. Thank you both so much.
They're clearly thinking about how to really make it work, aren't they?
Yeah.
With that, that's a really good sign.
Yeah, yeah.
All love to you. Thank you.
Thank you.